Her name is Christina Lynn Siders. She is 67 years old. She is a grandmother. And right now, her lawyer is asking a judge in Vinton County to make sure you never learn what happened inside that house. And the judge, as of last night, has not said no. That is where this story starts today. Not with the raid, not with the mother, not with the father, with a woman old enough to be somebody's abuela, sitting in a small county jail in southern Ohio, quietly asking a court to shut the door on the whole case, deeper, harder, more permanently than it has already been shut. Almost nobody has told you about her. That is not an accident. Everybody in America who has followed this case knows the young mother's name. Everybody knows the young father's name. The mother's lawyer has been on national television. The father is in court today on separate charges. Those two names have taken up all the air. But there is a third defendant in this case. There has always been a third defendant. And her name, the one the reporters keep skipping past, is Christina Lynn Siders, age 67, grandmother. She has her own lawyer, her own strategy. And this week, her own quiet motion filed in the Vinton County Court of Common Pleas. Her attorney is a woman named Kandra Roberts. And the motion Kandra Roberts filed on her behalf has a name most viewers have never heard before in their lives. Non-dissemination order. Say it out loud. Non-dissemination order. It sounds like a paperwork thing. It sounds like something you would sign to open a bank account. It is not. In the world of a criminal case, a non-dissemination order is one of the most powerful legal tools a defense attorney can ask for. And it is very different from a gag order. Most people, when they hear the two words together, think they mean the same thing. They don't. And the difference matters more than almost anything else that is happening in this case right now. Let me explain it the way I would explain it to somebody at a kitchen table. A gag order restricts what people can say out loud. It says if you are a lawyer, a witness, a party, a police officer involved in this case, you cannot go on television and give an interview about it. That is what the July 14th order did. It told the mouths of the case to stay closed. A non-dissemination order is different. A non-dissemination order restricts the paperwork, the files, the discovery, the materials the prosecution shares with the defense during the case. It says you can look at these documents inside the courthouse, but you cannot copy them, forward them, share them, hand them to a reporter, or make them public in any way. Not now. Not ever, unless a court says otherwise. So a gag order silences mouths. A non-dissemination order silences everything downstream. Every police report, every photograph, every witness statement, every recording, every text message pulled off a phone, every child welfare document, every school record, if any of the children were ever enrolled anywhere, every medical file, every single piece of paper that would ever tell you in your own home, on your own screen, what happened inside 182 Omer Street. If the judge grants Kandra Roberts' motion for Christina Lynn Siders, the case does not just stay partially sealed, it gets close to fully sealed. Deeper than the July 14th order, broader, harder to fight. And it happens before the case has even reached a grand jury. Now, some viewers are going to hear this and say, that's normal, isn't it? Every case has some protection like that. And the answer is not really, not this broad. And that is exactly what the outside legal community is starting to say out loud. A scholar named Nora Demleitner sits on something called the Council on Criminal Justice. She is a nationally respected voice on how sensitive criminal cases should be handled. And this week she said in plain words that any order this restrictive, any request to seal this much, has to clear what she called a high bar. That is a legal phrase. In plain English, it means the judge is not allowed to just grant this because a defense attorney asks. The judge has to see actual, specific proof that leaving the information open would hurt the fairness of the trial. Not general worry, not gut feeling, proof, case-specific proof. And Nora Demleitner is not alone. A defense attorney named Michael A. Fratta also spoke publicly this week, and he made the point even sharper. He said the original July 14th gag order, the one that came before this new non-dissemination motion, is missing the case-specific evidentiary findings that Ohio law requires, meaning the piece of paper the judge signed does not lay out the exact reasons tied to this exact case that justify closing the door. If that is true, then Kandra Roberts is now asking a judge to stack a second, broader, harder to attack order on top of a first order that may not have been legally sound to begin with. That is not a small thing. That is legal architecture that could collapse the whole structure if the appellate courts get their hands on it. But non-dissemination orders can also be used defensively. as a shield, as a way to make sure that the fewer eyes on the paperwork, the harder it is to build a public case for accountability. And when you look at a defendant who is a grandmother, a person the public instinctively feels less anger toward than a young parent, and you see her lawyer reaching for the most restrictive tool in the shed, you have to at least ask the question, what does Christina Lynn Siders know? She has been in the world for 67 years, almost 7 decades, long enough to raise her own children, long enough to see her son grow into a man, long enough to be present in some way in the lives of the 16 grandchildren the state now says lived in a room the size of your bathroom. She was not a bystander. She was, by the state's own filings, a co-defendant, which means the prosecutor has already put on paper that they believe she was part of what happened inside that house. And now her lawyer is trying to make sure nobody outside that courthouse ever gets to see the pieces of paper that back that up. That is the shape of what is happening this week in Vinton County. Meanwhile, the judge sits on it. Judge Laina Fetherolf Rogers has not ruled on the motion. As of last night, the paperwork was in front of her. The arguments were on file. Kandra Roberts had made her case. The prosecution had responded, and Judge Rogers had said nothing yet, one way or the other. That silence is its own signal, because the longer a judge holds a motion like this, the more you can guess she is wrestling with it. If it were obviously wrong on the law, she would have denied it fast. If it were obviously right, she would have signed it fast. The wrestle is what tells you the outcome is close, and close in a case this big is dangerous, because close means the ruling could go either way, and either way changes the case. If she grants the motion, Vinton County becomes arguably the first Ohio county in modern memory to fully seal a pre-indictment child endangerment case of this scale. That is a legal record. That is a headline. That is a First Amendment fight waiting to happen. If she denies it, Kandra Roberts' defense strategy takes a real hit, because the sealed material she was hoping to protect is now potentially in play. Both outcomes are big. Neither one is quiet. Now here is where I want you, at home, to think about something bigger than the paperwork. Think about the human piece. Think about the grandmother. In many families across this country, including in a lot of Hispanic households, the grandmother is the moral center. The abuela is the one who says, this is not how we do things. The abuela is the one who steps in when a parent falls apart. The abuela is the one who protects the children when nobody else does. That is a role, a real role, a sacred role in a lot of homes. And so when you hear that in this case, the grandmother is a co-defendant, not a rescuer, not a whistleblower, not a hero. You feel it in a different place. It is not just legal news. It is a shape of the world that feels wrong. Because grandmothers are not supposed to be on the wrong side of the door in a room full of hungry children. That shape is what the non-dissemination order is trying to hide. Not the paperwork, the shape, the picture, the version of Christina Lynn Siders that the discovery file would draw for you if the public ever got to see it. Right now in Vinton County, 3 things are on the table. The first is the July 14th gag order. That one is being sued over by the Columbus Dispatch and questioned by former prosecutors. The second is today's court date for the father, which is on separate misdemeanor charges. The third, the quietest, the one almost nobody is watching, is the non-dissemination motion for Christina Lynn Siders. And this third one, if granted, is the one that would go the furthest to shut down what you and I ever get to learn about this case. Watch the third one. Watch it hard, because it is not going to make headlines when it is signed. It is going to be a paragraph, maybe a 2-sentence entry on a docket, and by the time you notice, the paperwork inside the case will already be off the table for the rest of your life. A 67-year-old grandmother sitting in a Vinton County jail is asking a judge for silence, and the judge has not said no. The next thing that judge decides will tell you a lot more about the direction of this case than anything the lawyers say out loud. Here's a thing I want to explain, because a lot of viewers hear the phrase pre-indictment and their eyes glaze over. Pre-indictment matters. It matters enormously, and it is the piece of Christina Lynn Siders' motion that most reporters have not caught yet. An indictment is the formal charging document that comes out of a grand jury. In serious felony cases in Ohio, the state does not just arrest you and take you to trial. The state has to convince a grand jury sitting in secret that there is enough evidence to charge you formally. Once the grand jury indicts, the case becomes public in a much bigger way. The charging documents become part of the record. The evidence starts moving. Witnesses get subpoenaed. the whole engine turns on. Before indictment is a different world. Before indictment, the case is quieter. Fewer documents exist. The ones that do exist are held closer. And that is exactly the moment Kandra Roberts picked to file the non-dissemination motion for the grandmother. The timing is not accidental. If Judge Rogers signs the order now, before indictment, the effect ripples forward. It shapes what becomes public later. It sets a precedent inside this case that any future filings, any future discovery, any future evidence will be handled under the tightest possible seal. That is why the motion is dangerous. It is not just about today, it is about every day after today. And the grand jury piece has its own weight too, because a grand jury does not sit and hear both sides. A grand jury hears the prosecutor's case. That is it, which means the version of the story that goes in front of the grand jury is a curated version. It is the state's version. And if the case has been quietly sealed up before that grand jury ever sits, then the counter-narrative, the defense's version, the neighbor's version, the family's version, never enters the record in a way the public can access. It just sits somewhere on a hard drive, locked up under a non-dissemination order, waiting for a trial that may or may not happen for years. And there is a human piece here too, because when a case gets locked down like this, the people who lose most are not the reporters. They are the extended family, the cousins, the aunts, the neighbors, the people who might, in an open case, come forward with information. Not because they want the spotlight, because they saw something, because they know something, because they can't sleep at night thinking about it. When the case is sealed, those people stay silent, not by choice, by fear, because they don't know what they are allowed to say. They don't know if a judge is going to come down on them for talking. They don't know if their name is going to end up on a court filing. And so they keep it to themselves. And the state loses information. And the case gets shaped by what the lawyers already have, not by what the community might still be able to add. That is another reason non-dissemination orders are supposed to be rare, because they don't just hide the paperwork that exists. They chill the paperwork that has not been created yet. They shut down tips. They shut down whistleblowers. They shut down the ordinary people who might otherwise have written a letter to the prosecutor. In a case involving 16 children, that chilling effect is not a small cost. Kandra Roberts knows all of this. She is not filing this motion by accident. She has read the case law, she has read the discovery, she has looked at what her client is facing, and she has made a strategic decision that silence in this specific moment, in this specific courtroom, is the best thing she can build for Christina Lynn Siders. The judge sitting on that motion has to weigh two things. She has to weigh Kandra Roberts' argument that her client cannot get a fair trial with the paperwork public. And she has to weigh the argument the media coalition is starting to make, that the public has a right to know what is inside the paperwork of the biggest child endangerment case in Ohio in a generation. Both sides have real weight. That is why she is not ruled. That is why the wrestle is so long. And that is why what happens next in this quiet motion may matter more than any of the loud news around it.